With more on these incredibly dangerous developments, we're going to go to Stewart Rhodes. He's a constitutional lawyer who won awards at Yale for his reports and papers on the belligerent act and the whole enemy combatant question. In fact, the paper was titled Solving the Puzzle of Enemy Combatant Status back in 2004. He also, of course, worked in Congress for Ron Paul, and he's the founder of Oath Keepers. He's an Army paratrooper veteran himself. And again, I saw mainstream articles last night and this morning saying that the bill passed, the amendment passed, and I rarely get caught up in something, but then later I learned it didn't pass. It was just that it's passed out of committee and that they're trying to bring cloture so there can't be a debate on it or a filibuster. We're going to get Stewart to talk about that. And the amendment failed. The amendment failed. But this is just incredible. And if it goes through the Senate, then I guess it'll go on to the president, who claims he's going to veto it. But the president's already declared the power to kill American citizens, as they've already done with the Lockheed in that staged event to set the precedent. They've already said they can secretly arrest people and detain them. He said last year, I don't need this legislation. I'll do it through the executive. So it's a lot of politicking to manipulate the public. As one congressman, Amash, said, this is carefully crafted to mislead the public. A week ago, they would say, oh, this doesn't affect citizens, because one provision says that. But then the other provision says, but it does if we say so, basically. Now, an expert, I mean, you couldn't think of a better one, military guy, constitutional law scholar, won awards for his research on this, worked for Ron Paul, knows Congress, knows all the Byzantine things that are going on. Stewart Rhodes can break this down for us. But there's the latest article. Indefinite detention bill set for final vote Thursday. Senate moves to limit debate on unconstitutional legislation. That's up on Infowars.com, the latest there. But again, last night I heard it passed, got up this morning, read articles, said it passed. That's the mainstream media. I've got to learn to just believe nothing they say. It's so incredible. I remember 4 years ago when NATO attacked the Russian-held area of South Ossetia and Abkhazia. For 2 hours, I was reporting, well, the Russians attacked it. Can't believe they did, because CNN was saying it. Turned out it was NATO attacked. I mean, it's just that even I get caught up in their lies. I mean, it's incredible. It's incredible. Stewart Rhodes, great to have you here with us, my friend.
Thank you, Alex, very much.
Okay, so you wrote the papers on this. You've been an expert on this. You pointed out before we went live here, the belligerent act is really McCain's real holy grail, where if you're just belligerent, you disappear into a black hole. So now they're trying to get it piecemeal. Break this down.
Well, yeah, in the 2010 Belligerent Detention Act, he wanted the language to read that if you commit an act of belligerence and warfare or any other act of terrorism against the United States, then you could be, if you're just accused of that by someone in the executive branch, you could be whisked away into military detention, no grand jury indictment, no trial in front of a jury of your peers, just taken off to Guantanamo. He didn't quite get what he wanted, but what he's doing here is getting what he can. He's attaching this, making this part of the defense appropriations bill, which no one wants to vote against, or they're just, described as being against the troops, and he talked a Democrat, Levin, into proposing it. But really, it's McCain's baby, and this is him getting what he can. What he's going to get out of this bill, if it passes, is Section 1031. The first part of it does apply to U.S. citizens, because it says that any person, a covered person under this section is any person who is accused of participating in 9/11 or aiding those who did it, or is accused of being part of Al-Qaeda or an allied group or supporting one of those organizations. And the mere accusation alone by the executive branch or someone in the Department of Defense would place you under military jurisdiction and then give the president the option of detaining you indefinitely, sending you off to Guantanamo. It expressly states that a person who is under that first section can be, one, detained under the laws of war without trial until the end of the hostilities authorized by the Authorization for Use of Military Force.
And the wars never end. We're always under an endless emergency. And those, before you continue, that say, oh, well, let us get tough. Why even have America then? Because America is about due process and is about checks and balances. So you can't stage things. So people get a day in court. I mean, this idea that due process is bad, all these people that say that, well, they should just move to another country. If they don't like due process, they should move to North Korea.
Yeah, if you don't want to live under the Bill of Rights and Article 3 of the Treason Clause, which is what this directly violates, then please do move to North Korea or China. So it states you can be detained indefinitely for the duration of the war on terror, which could be forever, or number 2, trial under Chapter 47A of Title 10 U.S. Code, which is the UCMJ as amended by the Military Commissions Act. And what that means is military tribunal, military commission. And it also has a section 1036. Some people say, well, you know, you get a right to challenge your determination. Well, it mandates in Section 1036 that if you challenge your determination, it will be a military judge that shall preside at proceedings for the determination of status of an unprivileged enemy belligerent. And it also states that you will get, if you want one, a military lawyer, not a civilian lawyer, only a military lawyer. So the point is that they're treating you, the American people, precisely the same as if you were an Iraqi or someone in Afghanistan in an occupied country. They're going to come into your house once they decided that you're a bad guy, or just that they don't want to call you a bad guy, say they don't like Alex Jones's speech. And so they designate him an enemy combatant and accuse him of aiding al-Qaeda in some way. That before you get a trial, before anything else happens, they come to your door, middle of the night, kick your door in, guys in black body armor come in, put a machine gun to your face and your children, and whisk you away to Guantanamo.
Well, wait, Stewart, it's worse than that, though, because we already have the MIAC and Homeland Security reports. We got a new one yesterday where the feds are telling all local police that State Rep Charles Key in Oklahoma, a great guy, and the victims' families of Oklahoma City who are investigating what happened there, they are listed as domestic terrorists. Actually, it says domestic terrorism section. It lists them, and even mainline libertarian websites. We've already seen Ron Paul having American flags. So the point is, they're already teaching the police and military this. They're already saying the returning veteran's the #1 enemy. You know, they sell it on it's al-Qaeda.
Oh, I know, of course, but point is like I said, he couldn't get what he really wants. He wants that wide open definition that includes or other acts of terrorism. But what he can get, and what he's getting so far, the Udall amendment yesterday to strike this provision was defeated. What he's getting so far is a definition that's supposedly narrow, that only applies to al-Qaeda or those affiliated. And
the same al-Qaeda they've put in control of areas like North Africa and Libya and are moving over to Syria. I mean, this all rings hollow when it turns out the globalists are running al-Qaeda.
What they're going to do, Alex, is what they'll do is they'll pass this bill like it reads now, and then later on, say the next appropriations bill for the Defense Department next year, they'll insert a very vanilla amendment that says insert at the end of this section or other acts of terrorism. And there you go. It'll be a wide open sweeping in of anybody accused of any act of terrorism. But even right now, all they have to do, this is the point, you won't get a jury trial, you won't get a grand jury indictment. They can just accuse you of aiding al-Qaeda through some means, for some nefarious means, and then whisk you away to Guantanamo. And when you want to challenge it, it'll be a military judge, handpicked by Obama, who will determine whether or not you are justified in being held. It won't be a jury.
But what about the sections dealing with using the military domestically? We know for decades they've been trying to do this, and we see Marines running checkpoints in California and Alabama, and Army checkpoints in Tennessee, TSA now at checkpoints around the country. I mean, they're already doing this, and they're already killing U.S. citizens abroad.
Well, that's the other part of it. That's the other part of it, is that the backdrop to this is that the Supreme Court in 2004, in the Hamdi decision, gutted the Bill of Rights. It's a horrible decision. I don't know why liberals keep saying it's some kind of victory for the Bill of Rights. It was nothing of the sort. I mean, even Judge Napolitano got it wrong last night in his interview with Rand Paul. You know, God bless him, but he missed it on this one. In the Hamdi case, Justice O'Connor, for the majority, made some flowery speech about how the power of the executive branch is not limited, but she went ahead and also said there's nothing in the Constitution that prevents the U.S. government from detaining one of its own citizens as an unlawful combatant. And then she said, but they have a right to challenge their determination, and they have the right to counsel. And in that decision, the only thing the liberals were arguing against back then was that Congress had not given authorization. Well, the Supreme Court ruled in the Hamdi case that Congress had given authorization in the 2001 authorization for use of military force, which even Ron Paul voted for. But he didn't realize they were going to use that to justify military detention. So what they've done is they've opened the door to the international laws of war being applied to the American people. And yes, yes, as I said in my paper back in 2004, if you can detain somebody under the laws of war, what else can you do with an enemy combatant? You can also just kill them on sight, which is what Obama has started to do. It's all about the laws of war. The NSA spying on the American people was defended by the Bush administration as being under his powers as commander-in-chief to surveil the battlefield. Obama now claims the power to go ahead and just kill you. It's all very consistent with what can be done to a foreign enemy in wartime.
Well, that was my next point, is that if you go back to the Military Commissions Act and all of that, I remember at the time covering it and having you and others on, you know, it says citizens are exempt unless the Defense Department or people they designate say that you're a combatant, and now you're basically extrajudicially stripped of the rights of a citizen. So it's all these games, and they say it over and over again. But what about the overall psyop last week and this week of saying it doesn't affect citizens, even when Lindsey Graham and even when John McCain admitted it did? We see that classic military psyop of trying to make the debate about whether it did this or not instead of debating, is this a good idea?
Well, that's Section 1032, and there have been some folks, even an article in the American Thinker that misread that. 1032 requires military custody, but then for certain people, but then exempts from that requirement U.S. citizens or lawful residents for actions that are committed here. What that means is that the president must detain someone in military custody if they meet the criteria, except unless they're U.S. citizens or lawful residents. And in that case, he's under Section 1031, he has discretion. So all it really means is that he must detain some people, but when it comes to U.S. citizens and lawful residents, he can do what he wants. He can try them by a jury trial for criminal statutes under federal law, or he can put them in military custody. It does not say that the military trial provisions or the military detention provisions cannot apply to American citizens. It just says that he has discretion. And this is something that I believe it was the other senator you mentioned earlier who got it right. He said, look, all it does is lead up to the president. And the president likes that. He is not opposing this detention policy. He's simply opposing that one section, 10.
And then, by the way, all the presidents do. I mean, you're a Yale constitutional award-winning lawyer. You know more about this than I do. But watching and studying it, the president then just lets the Secretary of Defense and then his designates do whatever you want. So people think, oh, well, this is special things just with the president. But the way I've seen this done in the past, the president then just designates it and creates his own military Praetorian secret police like the SS.
Well, that's correct. And this actual document itself calls for the establishment by the Secretary of Defense, in consultation with the Secretary of State and the Director of National Intelligence. You know, they set up their own system for determinations, and it won't be